Cortez.
Yes.
May I please, Lordship?
Yes.
My Lord, I beg to mention item number 3. My Lord, here I'm yet to receive CD. So kindly allow me 1 week time, my Lord.
3.
Yes, CD.
Wait, let me see. Oh, it's an AB.
Yes.
Case there is not there.
Yes, my Lord.
Okay. So, no.
Interim may be continued, my lady.
Interim is there.
It's interim.
Okay. Heard Mr.
Tip of home.
Itipa, the public prosecutor for the state of Nagaland, and Mr. So-and-so for the petitioner. You are V. Achumi.
We actually.
The learned public prosecutor states before this court that the case diary is yet to be received. And as such, he prays for some time, which is not objected to by the learned counsel for the petitioner. List this matter after, when can you bring?
After a week, my Lord.
After a week, so I'll give you a date. So let it come up on 22nd then. Oh, no. Yes.
24th.
24th.
Yes, my Lord.
Thursday.
Yes.
List the matter on 24th.
Okay.
My lady, interim may be
Then,
continued.
Yes.
interim order passed earlier shall continue till the next date.
Much obliged.
Bring the case diary on the next date.
Okay. May it please, your Lordship.
Yes.
Lordship, I beg to mention here in item number 22. My Lord, may I pray that this method
Item number 22.
Lordship, here in item.
Today the court is sitting till 1 o'clock because there is a reference of Honorable Judge Suman Shyam on his being transferred to Bombay High Court. So hearing matters, I have my doubts whether it will be done. Item 22, right?
Lordship.
Okay.
Let it be listed on 28th of July, Lordship.
24 matter, not very long. What about the respondent? Nobody seems to be appearing.
Lordship, here there's a sole respondent, but till today the respondent, they don't appear before this court.
Services otherwise complete.
Lordship.
So we can proceed, expert. right?
Lordship, but here the leading counsel is not here today, Lordship. So
Mr.
the letter can be listed on 28th of July, Lordship.
Okay, Mr. So-and-so, your seal, your name is there. on the-
W. Mahal, Lordship. My name is not reflected in the case list.
Mr. So-and-so submits that the leading counsel is indisposed.
Lordship is, yes, Lordship.
Is indisposed and as such has prayed for some time. Prayer is allowed. List the matter after 2 weeks.
Lordship. Lordship, it can be listed on 28, Lordship, if it can be listed.
28th
8 of
of
July,
July.
Lordship.
28th of July.
Oblige.
May I please, the Lordship? Lordship, I beg to mention hearing item number 14, Lordship.
14.
Lordship, if this matter can come up after 3 weeks, Lordship.
You have informed the private parties.
Lordship.
Yes. And as prayed for by Mr. Swenson, you are there for the.
Yes, Lordship. I'm for respondent number 5.
Okay. As prayed for by Mr. Swenson, appearing for the petitioner, list this matter after
3 weeks,
3 weeks. This is 21 matter.
Lordship.
Okay. 3 weeks. I'll give a date. On that day, you do it. So let it come up on.
Lordship, I'm yet to receive instruction, Lordship. They have filed an amended petition, Lordship, by including one of the respondent, Lordship. And to that effect, I'm yet to receive instruction from the.
After 3 weeks.
Lordship.
You are also there. You were there in that matter.
Lordship, I'm the petitioner.
Okay. Achha, so petitioner and respondent number 5 appears. Huh? Counsel for so-and-so appears.
May I please, Your Lordship? I beg to mention item number 4. The service. Yes, my lord. The service report upon respondent number 10, 11, and 12 is still awaited. So I pray that this matter may be listed after 2 weeks.
It has come up for orders. Let it reach and then we can pass the order. Right. This has come up for orders only, as you have said, the service is not complete.
Yes, my lord.
So let it come up. It is only item number 4. I'll see the order. Okay.
Yes, my lord.
May I please, Your Lordship?
Lordship, item number 5.
Hmm.
I pray that the matter is under process. So I pray this matter may be listed after 3 weeks.
It is in the orders. Let's
Yes,
see
yes.
what is
Okay.
what was the last order. Okay.
Okay.
It will read soon. Don't worry.
Please, Your Lordship. Lordship, I beg to mention hearing item number 12. The leading counsel here is out of station, so kindly list this matter after 2 weeks, Lordship.
Mr. So-and-so submits that the leading counsel is out of station and as such has prayed for some accommodation. Prayer is allowed. List this matter after 2 weeks.
Yes, Lordship.
After 2 weeks.
Much obliged.
Lordship. I beg to mention hearing item 20 on behalf of Sir Ali Sheikh. He's a outstanding counsel and he's having a personal difficulty to reach Dimapur. So on his instruction, I pray that matter be listed on 4th August.
Same prayer as prayed for by the so-and-so who has submitted that the leading counsel is an outstation advocate and who is not able to appear before the court today.
20.
As such, he has prayed for listing the matter after 2 weeks. Prayer is allowed. List the matter after 2 weeks.
No, on 4th August.
Oh, acha. He has prayed for some accommodation. List the matter on 4th of August.
Oblige.
May I please, Your Lordship? I beg to mention item number 21.
Item
Yeah.
number
21.
21. Okay.
Here the leading counsel is having some personal difficulties and
Acha.
I've taken the consent from the opposite counsel. Therefore, kindly grant us 2 weeks time.
Okay, Mr. So-and-so appearing for the petitioner submits that the leading counsel has some personal difficulty. And as such, he has prayed for some time. Prayer is allowed. Oh, so-and-so is also present. Prayer is listed after 2 weeks.
I oblige.
May it please, my lord. Lordship, I beg to mention hearing item 15 and 16. Similar matter is pending before the division bench. Same department, same question of law,
Acha.
which is why it will be more wise to take it up for after the division bench.
Or it can be
Discussion is
taken
passed.
up together. Why don't we tag it along with that?
No, it's all right. I don't want to take it up.
Oh,
We do, yes, yes,
Bench matter. This is single bench matter.
yes, that's all.
oh, that is before the
Yes.
division.
Yes,
bench.
yes, yes.
Acha. So it's better that we wait for some time.
Yes,
Yes.
my lord.
The matter is over.
Yes.
It is stated by Mr. So-and-so that this similar matter is pending disposal before the
Division bench.
honorable division
My
bench.
lord, my lord.
And as such, he has prayed for some time. Prayer is allowed.
List after
List-
4 weeks.
List the matter after 4 weeks.
Deeply obliged.
May I please your lordship? May I please your lordship? Lordship, I beg to mention item number 17,
Item
18.
number 8,
8,
yes.
hearing, okay.
The arguing counsel for the petitioner is an outstation lawyer, so kindly allow 4 weeks' time.
This is 2019 matter. See, it has been pending for so long.
Your Honor, there is an interim order.
So that is why we are praying for time. But then you should do it. It's a very old pending matter.
Your Honor, the arguing counsel for the petitioner is an outstation lawyer.
Acha,
That
you
is
do
why-
it. What is EB counsel? EB legal?
Yes.
What is that EB legal? That is
uh,
reflected in the cause list? Beside the name of the counsel?
Yes, name of the counsel.
No, EB legal. There is something which is written, I cannot understand. Acha, as Ms. So-and-so has prayed before this court that the arguing counsel is an outstation advocate and that he has some personal difficulty in arguing the case today. As such, she has prayed for some time. Prayer is allowed. List the matter after 2 weeks. Okay, I'll give you a date. Do it on that day. Otherwise, okay, this is the last adjournment actually. You do it on August 12th. List the matter on August 12th. Let him know. I mean,
Yes,
tell him
Your Honor.
he is an outstation advocate. Let him come and do it.
Yes, Your Honor.
List the matter on 12th of August.
May I please your lordship? Lordship, I beg to mention item number 17 and 18, lordship.
Yeah, please, Lordship. Lordship, I beg to mention hearing item number 13, Lordship.
13.
Yes, Lordship. On behalf of counsel for the respondent number 2, Lordship. Lordship, if this matter can be kindly listed after 3 weeks.
I have no objections.
Yes.
I am for the petitioner.
Mr. So-and-so, appearing here for the respondent.
Lordship, I'm appearing on behalf of counsel for the respondent number 2.
Yes. So-and-so, appearing for respondent number 2.
Yes, Lordship.
Respondent number 2 submits that, what is the ground of your adjournment?
Lordship, the counsel for the respondent number 2, she's out of station, Lordship.
Acha, counsel states that the leading counsel is indisposed and has prayed for some accommodation. The prayer is not objected to by the counsel appearing for the petitioner.
Yes, my lord.
List the matter after 2 weeks.
Deeply
Much
obliged.
obliged, Lordship.
May I please, Your Lordship, may we please to mention hearing item number 9, 10, and 11.
19,
9, 10, and 11.
9, 10, and 11. Acha,
Lordship-
these are analogous matters.
Yes, Your Lordship,
Why? Why are you praying for time? This
Well-
is not 2020 matter. 5 years have gone by.
yes,
There's a
Your
stay.
Lordship. No, there is I am for the state, Your Lordship.
Acha, okay, okay.
Yes, Your Lordship.
Acha.
So since the council, I could not able to see the principal council, the council who is taking up.
So in an earlier matter, the council said that there was an interim order, right? Did we extend it? Interim order, no, there was another girl, huh? Okay, we had done it, right? There was another council, a lady council who had said there was an interim order. Not able to locate her. Okay, then.
Your Lordship, I think the petitioner is not ready. The senior council is absent.
Hmm,
So
you want time?
Yeah,
You want time?
yes. Your Lordship may list this matter after 2 weeks.
I'll give you a date, do it on that day, okay? Learned counsel for the petitioner, prays before this court that he is why you want time? Your leading,
Senior is having some personal difficulties.
he states that his person, the conducting counsel has some personal difficulties and has prayed for accommodation. Prayer for adjournment is also sought for by the government.
no, Your Lordship, I was advised ready. The
Okay,
petitioner.
okay. The said prayer was not objected to by the government advocate. List this matter on 14th of August. 14th of
Deeply
August,
obliged.
2025.
Much obliged.
Much obliged.
All hearing matters are mentioned.
Sorry for the indulgence, Your Honor. Chief, there is an interim order in item number 8.
There
So
was
let it
another one, I
continue.
think. Oh, you have written? Okay, fine. That will continue till the next date.
May I please your lordship? Lordship, I beg to mention item number 17 and 18, Lordship. May I please, your
For
Lordship?
motion from the supplementary cost list.
I beg your
item
lordship,
number-
I beg your lordship indulgence, your lordship. Item number 18. the-
18.
Yes, no, your lordship, item number 31, sorry, my lord.
31.
31, the counsel for the petitioner actually has informed me last evening that he is going out of station, your lordship. I thought that they are going to,
Oh, you are there?
Yes, I'm appearing for counsel for the petitioner.
Acha, okay. Ms. So-and-so, appearing for the petition, appearing on behalf of Mr. L. Iralu. Prays that the leading counsel has some personal difficulty in conducting the case today. The prayer is not, as such, she has prayed for some time. The prayer is not objected to by the government advocate. List this matter after 2 weeks. This is which year's matter? 24. It's okay. List this matter after
Lord,
2 weeks.
lordship. I'm deeply obliged.
May I please, your Lordship? May I please, your Lordship? Lordship, I beg to mention item number 17 and 18, Lordship.
For motion, item number
Lordship.
23.
I beg to mention hearing item number 17 and
17 and 18, Lordship.
Acha. Otherwise, the item was already called. What matter you are mentioning?
17 and 18, Lordship.
17, 18.
Yes, Lordship.
Lordship.
Acha. What happened? Again,
Lordship,
your senior
the-
counsel is not there.
Lordship, it's not that the respondents, they were asking for time, but
Acha. This is a joint prayer in a way,
Yes.
right?
Lordship.
Ms. So-and-so appearing for the petitioner and you are there for the respondent.
No, I'm for
Lordship.
item number 23.
Oh, yes. Now she's mentioning another matter. Has prayed that the leading counsel has some personal difficulty and has prayed for some accommodation. She has also submitted that the learned counsel for the respondent had also prayed for time. Prayer is allowed. List this matter after 2 weeks.
Lordship, let it come up on 31st, Lordship.
Hmm.
Yeah.
This is revision coming up for the first time.
May I please, your lordship?
Yes.
Your lordship, this application filed under Article 227 of the Constitution of India,
Mm.
read with section 115 of
Mm.
Code of Civil Procedure
Mm.
1908.
This is for compensation.
Yes, your lordship.
Hmm. Yes.
Your lordship,
Today it has come up for the first time. Let me issue notice. What is your prayer?
my prayer is that
No,
we humbly pray that your lordship gradually allow this petition by quashing and cite the order dated 13/25 passed by the Honorable District Judge Zanamboto, consequently reinstate
Hmm.
MSLS PP Infra as an initiative party in civil suit number 1 of 24. We also pray that
Or
civil
that
suit,
impleadment was not allowed.
yes,
Well, show me that order of 13-6.
your lordship, page number 51. Annexure 8.
51. Yes. Well, what is the operative portion? This is a long order.
Your lordship,
What is the operative portion of this order?
yes.
Defendant number 3 was struck off.
Yes, your lordship.
Are you prepared with the matter?
Yes, your lordship.
Acha. No, what happened? Defendant number 3 was struck off from the parties.
Yes, your lordship. Defendant number 3 was struck up from the party.
Against that you have challenged.
Yes, again.
Why defendant number 3 was struck off? Because he is not liable to pay any compensation. He is the contractor.
Yes, he's contractor. He's liable to pay the compensation. Your lordship, in annexure number.
Today I'll issue notice. On the next day, your interim will be considered. Come prepared. Okay.
Yes, ma'am.
This is a petition filed under Article 227 of the Constitution of India, read with Section 115 of the Code of Civil Procedure, challenging the order dated 13/6/2025, passed by the Honorable District Judge Junhe Bhotto, by which the IA by which the interlocutory application being IA number 3 of 2025 was allowed by striking out the name of the defendant number 3, that is Messrs. LPSS Infra, the contractor, from the civil suit number 1 of 2024. Issue notice to respondents returnable by 2 weeks. The petitioner to take steps for service of notice upon respondents by registered post with AD as well as by usual process
Your
within a period of 2 days from today. List this matter after 2 weeks. On the next, the interim may be considered on the next date.
Your lordship, one more prayer. The civil suit number 1 of 24, we stay until the disposal of this instant.
This is what I'm saying, interim order to be considered on the next date. You come prepared properly, okay? This is a long order. You have to show the operative portion and all.
It's a pleasure.
For motion, item number 24.
Please, my lord.
This is
Lordship.
the first time.
Yes, here is a case, lordship, where the victim himself is being prosecuted by the state.
Acha. Victim himself becomes
Yes,
accused.
yes,
It happens at times.
yes. Now,
Let the city come and we will consider.
no. Annexure 6, kindly.
Hmm.
This is on the teeth of the decision passed by this honorable court in PL application 2 of 2025, delivered by Justice Debashis Parua, and PL application 649, 2025, decided by Justice Mritul Kumar Kalita. Yes.
Huh.
Now, in those, I may be allowed to,
Hmm.
in paragraph 36, I'm sorry,
He is inside.
paragraph 36.
He is inside. The petitioner is inside.
Yes, he is inside. Now, in that, it has been clearly stated how Article 22, the grounds of arrest.
Grounds of arrest not
Yes,
there.
yes. It is there, but they cannot write Johnny eating sugar, no papa, and then treat it as grounds of arrest.
Where are the grounds of arrest? Show me.
Annexure 6. Page 26 of my PL application.
Hmm.
Now, here,
To prevent the accused from committing
Yes.
further case, further
Yes.
crime.
this
To
is,
proper investigation of the offense, where such as collection of evidence, arrest of the co-accused. To prevent accused from what? From
from causing.
Or from causing the evidence of the offense to disappear. Temper, to prevent the accused from so and so. These are actually regions of arrest, not
Yes,
grounds.
yes, section 35 of the PNSS, which is section 41 of the old CRPC.
Grounds like what?
Now
needs-
grounds, what it must contain, it has been succinctly stated in the decision that I've referred to in paragraph 36, Sakib Chowdhury. Paragraph 36, I may be allowed to.
Such in that those decisions by Supreme Court, what has to be there in grounds of arrest?
Yes, yes.
What
yes.
was that judgment? No, I mean,
That
after
Supreme Court
that,
decision, Vihan Kumar.
no, after Vihan Kumar, there was one more, or before that?
No, after Vihan Kumar, there was this Sakib Chowdhury. Sakib Chowdhury is based on Vihan Kumar.
No, before that, there was one. Maybe.
Here,
the judges
direction
have-
has been issued by this honorable court to give information and training to the judicial officers as well as to the police officers
Hmm.
under Article 22(1) and Section 47 of the PNSS.
A Probir Purcaster, I was saying. Probir Purcaster case,
My lord.
there the difference is made between arrest and the ground,
Yes.
regions and the grounds.
Yes. Here also, it states that this notice must be served on the arrestee at the time of arrest, should clearly state the grounds of arrest, including the full particulars of the offense, the gist of the accusations, and the basic facts necessitating the arrest. Failure to comply with this requirement would render the arrest invalid due to non-compliance with the constitutional mandate. Now in bail application 2 of 2025, this is a Kohima bench decision.
Hmm. Now you have given me Justice Holita's judgment.
Yes, yes.
What do you say on this ground of arrest?
Lordship, I may be given some time to obtain
No,
instruction as well as to
prima
examine
facie.
whether there is a violation of that fundamental rights, Your Lordship.
Let me
He's
see the
alleging
court,
that there is a-
case
yes.
diary also, there
Yes,
might be
yes.
something else.
Yes.
Then in
Without
that-
case diary,
In that case, my humble request is, this is the accused, he's a student,
Hmm.
21 years, and then he has already completed his diploma, and he was supposed to have joined his degree course. And this is a Ponzi scheme,
Mhm.
where Your Honor, Your Lordship is well aware of what is a Ponzi scheme. I may not deal with that,
Mhm.
but his future is at stake.
Yes.
So which is why a short date may be given. If
Uh-huh.
adult.
Yes, yes.
yes, yes.
CBS
A week's
This
time
is
will
from
do.
what place? This is from which?
Kohima,
Yeah.
okay, yes.
Only
Yes,
Yes,
yes. A week
Uh,
time, Your Lordship.
weeks, I will give you a date. Bring your case diary on Tuesday,
Yes,
22nd,
Tuesday.
Tuesday.
yes.
Let it be Thursday.
My lord, let it be
Yes,
Tuesday.
Thursday.
Kohima only?
Yes,
Yeah,
it's from
it's
Kohima only,
Kohima.
yes.
Yes, but corresponding text time.
23rd.
I have to obtain
In
the
fact,
court order
if it
after
is
that
called
only.
at
I have
2
to
also today,
intimate
it can
them.
be.
So-
Okay, on Wednesday.
Wednesday is DB. Your
No,
Lordship.
GB
We
will
don't
not
have-
be there, I
Oh,
think, this
okay,
time.
okay, that's
So Wednesday.
yes. yes.
Okay. Yes, this is a bail application filed under section 480 of the BNSS. 226 was not required. Why 226? You're not.
Because
paying
my
for any
fundamental
writ.
right is violated.
226 is for writ.
Yes, yes.
What
but-
writ here?
Yes, yes.
Okay, we'll not write. Under 480 of the BNSS Act, praying for bail, regular bail of the petitioner in connection with crime PS case number 0003 of 2024, registered under section 111, subsection 3, subsection 4, subsection 6, and section 318, subsection 2, subsection 3 and subsection 4 of BNS 2023. Call for the case diary. List the matter on 23rd of July 2025.
Deeply obliged.
You can take the judgment or I'll keep it here.
My lord, my lord. Much obliged.
For motion, item number 25.
Delay or what? Delay?
Yes, Your Lordship.
Delay of how many days?
105 days. to
Okay,
file
let
an-
notice be issued.
Okay. Obliged, Your Lordship.
This application is filed under Section 5 of the Limitation Act, 1963. praying for condoning the delay of 105 days in preferring the connected MSc appeal. Issue notice to the respondents. Number 1 to 7. These are all claimants or what? These are all claimants?
Yes, yes.
1 to 7 by returnable within 2 weeks. Petitioner to take steps of service of notice upon the said respondents by registered post with AD, as well as by the usual process. List this matter after 2 weeks.
For motion, item number 26.
This is also delay.
Yes, your lordship.
Similar order, only that I number what? This will change for 122 days. And respondents number 1 to 4. These are the changes 1 to 4. Oh yeah, connected MSc appeal. No, number is not given or given. 13.
13 years.
13 of 2025. If you notice, returnable.
Bless your lordship.
For motion, item number 27.
For the began insurance.
Yes, your lordship.
Here also delay.
Yes, your lordship.
Same order. Only that delay of how many? 105 days. 105 days. MSc appeal is not numbered.
MSc appeal is 14/2025, your lordship.
14 of 2025. And respondents are 1 to 7.
Mhm.
6 and 7, I think there's somebody who is appearing. 6 and 7 performer respondents.
Not yet, your lordship.
Okay, let the notice go to 1 to 7.
Bless your lordship.
For admission, item number 1.
May it please your lordship.
Please, your lordship. Lordship, the senior leading counsel in this matter is unwell today,
Is
so
this criminal
kindly,
petition?
fix a short date in this matter.
Someone is appearing. Acha,
Yes.
you're there.
My lord,
I think you're not audible.
my lord.
Yes, yes, you're audible. I can hear you. Oh, no, not now. I
Maybe
cannot
the
hear you.
lordship-
You're not audible.
My lord, till now I am not. Lordship,
You are not, I cannot hear you. There's something wrong with the microphone.
microphone is
lordship.
on, your lordship.
There's been some, I believe there's some technical issue, I believe, Lordship. If so, it is matter can be taken
After some time.
after some time, Lordship.
After some-
Yes. Oblige, ma'am.
For admission, item number 2.
May I please, your lordship?
Wait, let me get my file. Yes, yes.
During the pendency of this case, the parties have amicably entered into an agreement dated 19/6/2025,
Sure.
where
Yes, yes.
What is this matter about?
This is a custody case. A
Oh,
family,
the matrimonial
yes,
issue.
yes.
Okay.
Order passed in the interlocutory application was challenged before this honorable court. Now the main case has also been closed,
Okay.
yes, based on
Is-
the compromise entered between the parties.
Is it, have you filed any affidavit?
No affidavit has been filed, but the
Huh.
honorable court's order.
The main petition which was.
Yes, yes, yes. So we are here, aggrieved by,
Acha.
yes, the decision passed in the interlocutory application, not in the main case.
Mayang Zagri and Longchar. The case was custody.
Yes, yes. Regarding the custody of 3 children.
This is okay. Custody cases. What was this about? The present case about?
Your Lordship, we were challenging the order dated 21/9/2021, where the entire merits of the case was decided in an interim order. Passing the interim.
It was against 19/12/24. Where is that order? Just let me see. 19/12/24. Where is that order?
Your Lordship, it's in page 200.
200.
Yes.
So this was for interim custody.
Yes, Lordship. Interim custody was granted to me. So I grieve by that, they have approached the dishonorable court.
You are for the father?
Yes, Lordship.
This order is a long one, it seems. Is this the entire bunch is the order?
Yes, Your Lordship.
Okay, right. I'll dispose it off on the basis of this. Heard Mr. So-and-so you're for the petitioner, right?
Yes, Your Lordship.
And Mr. So-and-so for the respondent. The counsel appearing for the petitioner has placed a judgment dated 19/6/2025 by which a settlement by which the custody case number 7 of 2023. You can sit, both of you can sit. Custody case number 7 of 2023 was disposed of by virtue of a settlement arrived between the parties, that is the mother and father of the 3 children. The operative part is reproduced below, just A to A, you write it down, of the said judgment, or the operative part of the said judgment is reproduced below. The instant application, that is the criminal revision petition number 2 of 2025. Please switch on the fan. Okay. Switch on the fan by someone. Okay. Has been filed against an order dated 19/12/2024, by which an interim custody was allowed to the father. Interim custody of the children was allowed to the father who is respondent number 2. That is respondent number 2. Since the parties have entered into a settlement, to the effect that the custody of the child, of custody of all the three children is handed over to the father till they attain majority, right? Till they
Yes.
attain majority.
Yes.
And that the mother was allowed to have custody of the children on alternate weekends every month. And further, that she may also have custody on consecutive weekends. On the full stop, on the said agreement being reached between the parties, the main custody case number 7 of 2023 was disposed of by order dated 19/6/2025. In view of the said order, before that, the counsels appearing for both the parties have stated in the bar that in view of the said order, the present application may also be closed, since the same has become infructuous.
My lord.
It is noticed that for the welfare of the child, welfare of the three children, the parties have entered into an agreement and the court of Principal Judge Family Court, Dimapur, Nagaland, has also directed that both the parties shall agree to the agreement and will execute the same without any interference from any third party. In view of the order passed in the custody case number 7 of 2023, dated 19/6/2025, this petition stands closed. Stands closed. Petition is disposed of in view of the above. In view of the above, whatever. Okay.
Deeply
Is
obliged.
closed. Disposed of. In view of the statements referred, in view of the statements made.
For admission from the supplementary cost list, item number 28.
Or that, this one,
Yes.
contempt.
On that occasion, a
Ah.
submission was made that they didn't appear before the deputy commissioner.
Ah.
So witnessing
Today,
the,
what happened to the council?
oh, that I don't know. Now I'm just finishing my thing. So witnessing the online streaming,
Huh.
they have therefore appeared on the very next day. So they submitted a representation and certain photographs are there for your lawsuit's consideration to indicate that that submission cannot come now from their
Yes.
side. If I may just place it.
That he said that people have not gone and so they are
Yes,
unable
they,
to.
they have been going, but
Ah.
since their submission was made,
Hmm.
now they have gone there. Around 97 people have gone there, find the attendance there,
Hmm.
and photographs are also there backside. So now this ground also probably they cannot take that the people have not approached him. So money is there to be paid. They have approached him.
Hmm.
Let him pay the money. This honorable court may therefore fix a date by which time 100% compliance should be there, and in default, appropriate actions of personal independence should be there. That will be my submission.
Lordship, Miss, counsel for the petition.
Whether your affidavit is on record? On the
Lordship,
last
I have-
occasion?
Lordship, on the last occasion, I have filed my affidavit of compliance, Lordship.
Which was again little vague. Where was it?
On 14th, they have filed it. Is it on record? Lordship? Or I can just
Oh,
hand
yes,
over
yes,
my copy.
it's there.
Yes.
On 14th.
Yes.
Did
I was showing paragraph number 3, paragraph number 4,
Hmm,
wherein they say substantial compliance is there.
hmm.
And I also showed that total 177 people were the beneficiaries and only 18 have been paid as available from the annexes that has been appended to the affidavit.
Deponent issued a circular wherein all person stating substantial amount for damage has been paid. This is what your
Yes.
stand was.
And if you also will see
Huh.
the list that they have annexed at page 21.
Page
Page 21.
Yes.
People who have been given the money,
Mhm.
and then lots people see at page 24, where the list ends,
Hmm.
is only serial number 18, 24. Page 24.
Rest are the photographs of their taking money.
Yes.
24.
The register where they have signed. So
Ah.
it starts at page 21, ends at page 24.
So only 18 persons.
Only 18. So what my submission was,
Hmm.
when the list of beneficiaries is 177, you make payment to only 18.
Hmm.
How could you in your affidavit say the substantial compliance has been done?
Hmm.
And then the submission came without any pleadings that they have never appeared to collect their money. So though I had controverted that on that occasion by saying that this is not believable,
Hmm.
still the next day they have all gone there,
Hmm.
submitted their attendance, 97 or 99 people were there, and all photographs are there for lordships to witness that this is the situation. They are there waiting for the response from the Deputy Commissioner for release of the money,
Hmm.
and Deputy Commissioner is taking his own sweet time to release. That day, some amounts have been released, but then all have not been released for reasons best known to the contender.
So they have all gone? Whether all 99 have gone?
Lordship, if they have met an submission, I will also make my submission.
Achha.
No,
He has already finished. He said
my
that the 99 people have gone there.
on that day, these people have gone there.
And
Okay.
some of them were paid.
Then Lordship, I'm allowed to make my submission, Lordship.
Yes.
I'm for contempt number 5, Lordship. Here, what happened, Lordship? Yesterday.
You are for the
yesterday-
Deputy Commissioner?
I'm for
present?
Deputy Commissioner, Lordship. Now, Lordship, Deputy Commissioner, the money has been sanctioned, released, the money has been released from the MRT Ministry, Central Ministry. Now, what happened, Lordship? Now, the money is with the Deputy Commissioner. However, Lordship, Deputy Commissioner, who is the authority to disperse the amount, Lordship, the Deputy Commissioner is also answerable to the government and also answerable to the Accountant General.
Yes.
And he is also answerable for the audit. So there is a certain procedure that has to be followed, Lordship. And Lordship, because of that procedure, Lordship, it is taking time. And moreover, Lordship,
That following of procedure will take so long.
Lordship, in
Because
fact,
judgment
there
in
was
order
change of
is on
guard, Lordship.
February 24.
Lordship, there was change of guard. Earlier, Deputy Commissioner one Ramnikan was there. However, there was change of guard. Now the new DC has taken
These
charge,
grounds
Lordship.
will not.
And Lordship, thereafter, Lordship, once he took over the charge, circular was issued on 11 June 2025, informing all the affected landowners and the beneficiaries to come in person on 18 of June for disbursement of the compensation
By that
amount.
circular.
By that circular, Lordship. Thereafter, some has already been released. And in fact, on 16, more than 90 to 100 affected landowners, they approached the authority. And the authority has said, please, authority has said, yes, at one go, we cannot give it to all. Well, since we have to verify everything, only after verification, Lordship, just one instances. In the verification report, earlier verification report, there was the affected owners was in the name of the village council.
Mm.
And after verifying, it is found out that that land belongs to one of the private parties, private individuals. And there was a
So those
lordship.
exercise
So
took time.
that exercise is
But
taking
then-
time. And in fact, on 2 days,
Mm.
I think more than 20 to 30, I would like to place that on report.
Acha, acha. Now, what was the direction, Mr. Sharma? Will show me from the.
Page
I will
19
come
of
to
the contempt.
Direction,
petition.
lordship.
Huh.
Direction of this honorable court, lordship.
Page
Lordship
19.
may kindly come to the direction, lordship, come to my affidavit, compliance affidavit.
Now, first of all, let me see the direction.
Lordship, compliance affidavit, page 13 of my affidavit, compliance affidavit. I have already annexed
Page 30.
page 10, operative portion. Last 4 paragraph, lordship. Last 4. Page 13, the operative portion. The deputy commissioner, if lordship has got it.
Page 13,
Page
paragraph
13,
11.
para last 4 paragraph, the operative portion, the deputy commissioner. The deputy commissioner / district collector, upon receiving the deposit, shall disperse the compensation amount to the affected landowner immediately by observing formalities. Here it says that observing formalities as may be required. The PIL accordingly stands.
Otherwise, what time was given? Disposed of with a direction to submit a proposal within a period of 1 month.
Within the period
To
of
the
3
state
months,
government to submit a proposal along.
lordship, that is the proposal, lordship.
Huh.
However, lordship, the operative person will start from the
Upon
last 4
receipt of the
paragraph.
proposal shall within a period of 3 months accord sanction and make the required fund available. So that has been done. To
Lordship,
the affected owners through the deputy commissioner.
lordship,
That's deputy commissioner on receipt of will so and so.
lordship.
So of course that time is not there.
Time is
Deputy
not there,
commissioner
time is
will
not there.
observe the formalities and give the money
Lordship,
after it was
lordship.
sanctioned by the.
By the
so and so.
importage.
So what I'll do is, as he has also suggested,
Lordship.
because some of them have got,
Lordship,
and then the rest will go, and then the deputy commissioner will disburse the amount.
oh, lordship, lordship,
And I'll fix up a date.
lordship,
By that date,
lordship,
will it be okay? By that date,
lordship,
the payments will be made.
Lordship.
What do you say?
Yes, Lordship, that is what I was suggesting.
Ha, ha, ha.
In fact, Lordship, what he is now trying to harp upon is on the word formalities.
Mm,
Now, if your Lordship will see the judgment,
mm,
the judgment is, if I may therefore place the judgment
mm,
once.
yes, yes.
If your Lordship will come to my contempt petition, where I have annexed the judgment copy,
Contempt is where? This is affidavit. Completeness.
there is no dispute.
One second, I'll just take out the
Yes, Your Lordship.
contempt.
Yes, Your Lordship. 21 or 24.
Yes, which page?
Page 16.
Yes.
I will just place the relevant
Hmm.
statements made in the judgment to indicate that there is no dispute regarding the quantum
Mm,
as well as on the assessment data.
mm,
So just to place that, we'll also will come to paragraph 3.
mm,
Now, from below, if
mm.
you also will see in the middle, the chief engineer, PWD, NH government. Lordship will see that?
Yeah, yes.
Middle.
The chief engineer.
Yes, the chief
government of-
engineer, PWD, NH, government of Nagaland, via communication dated 5/9/2017, informed the respondent number 11 regarding the assessment made for the damage caused due to the execution of the work, which also includes the stretch of road referred to in the instant PIL, Juneboto Sakabama Road, in respect of Kohima district. The assessment has come to the tune of 44 crores, 70 lakhs, 9,719.74.
Mm.
Despite the said assessment, since the amount of compensation was not paid to the landowners, this instant PIL was filed.
Mm.
Now, if you'll also see that assessment,
That was done.
this date was there.
Mm.
The copy that I had given the last occasion, 177,
Mm.
the date is 5/9/2017. So this is the document which was before this honorable court in the PIL that was to be looked into for the issue of compensation.
Mm.
Now, Lordship will see the paragraph 4.
Mm.
Mr. So-and-so learned counsel for the petitioner submits that a number of writ petition and also a PIL were filed by the affected persons, and the writ petitions have since been disposed of, directing that the assessed amount to be paid to the landowners concerned. So this was not the only amount. Total amount was 120 crores in the entire state.
Mm.
So various writ petitions and PILs were filed, and those people have already got their money.
Mm.
So this was one of those petitions.
Mm.
Now, if your Lordship will come
to paragraph, page 18,
Hmm.
paragraph 7, just above that. Paragraph 7, just above that.
Hmm.
Therefore, it starts with the line
Yes,
therefore.
it is clear.
Therefore, it is clear that the present case is squarely covered by the directions already passed in the bunch of writ petitions disposed of by the order at the 21/11/2023 and also in PIL 9 of 2019. And therefore, a similar direction may be given to the respondents' authorities concerned.
Mm.
And then Lordship will now come to paragraph 9.
Hmm.
Upon hearing the learned counsels for the rival parties and upon perusal of the materials on record, we are of the view that there cannot be any impediment in disposing the instant PIL as there is no dispute with regard to the amount so computed towards compensation. So today it is not open for the Deputy Commissioner to again reopen that issue, because the submission on the day when the adjudication took place was that there was no dispute with regard to the amount so computed towards compensation. So this particular list of 177 persons were there in the PIL, was a part of the record based on which we asked for a mandamus that this amount to these people should be paid. And therein, the government had all the opportunities to have argued on that list. What the government said was, yes, we are agreeable to this. And that is in paragraph 9. It says that the amount, there is no impediment for payment of the amount, as there is no dispute regarding the amount computed in that assessment sheet.
So the amount is 4 crores, no?
No
Yes.
dispute.
Let's
We are
go-
not disputing with the amounts. Okay.
Okay, let him finish. 4 crores 70 lakhs, right?
4 crores 70 lakhs,
Hmm.
that is to be paid to those 177 beneficiaries, coming to 4 crores 70 lakhs. So the case was filed by us espousing the cause of all these people, saying that this is the amount that is to be paid to these 177 SSCs, and that amount comes to 470. We had annexed that assessment sheet prepared by the government. This is not our list, prepared by the government. That was adjudicated upon. Government contested that, and finally the government said that yes, we are agreeable to this. Government said there is no dispute. And then the Honorable Court, basing on the earlier judgments passed for the other areas where money has already been disbursed, said that this case is also squarely covered, and therefore this money has to be paid. There cannot be any impediment.
Yes.
Based on that, the Deputy Commissioner as of now is supposed to clear. And when the reward formality is used, this formality would mean me when I go before the Deputy Commissioner, whether I am Mr. A is to be seen. How do I do that? By producing my photo ID and probably my account number to say, I am Mr. So-and-so, this is my photo ID. I figure with serial number so-and-so of that list, and therefore please issue my check. And therefore this is my account number. So the formalities, the definition of formalities herein would be circumscribed to only that requirement. It cannot be to reopen the very issue again, because that issue has already been decided by the Honorable Division Bench in a PIL matter, to which there is no appeal. So therefore, today to say that we are now going into the verification, probably in my humble submission is not open to them in a contempt jurisdiction. When there is a statement on record to say that there is no dispute regarding the amount computed. The amount computed is against persons, corresponding persons in the list. So now today that list is sealed. If you really want to open that list, you have to file an appeal or a review. That they have not done. So in a contempt jurisdiction, they cannot make this submission.
No, as far as the compensation is okay, there is no dispute and they have not. They have accepted that this much has to be paid to the persons.
Right.
But about the persons, about the beneficiaries, the people who will get it,
Yes.
that list will have to be again examined.
Again, examine, Lordship has rightly pointed out, Lordship, some of them has already died. And
Their heirs will get it.
Lordship,
Yes. Huh.
they will get it.
Huh.
But kings and queen,
Huh.
they will have to approach the authorities.
So that
Yes.
formality they will have
Lordship.
to do. I have
And
no
then
doubt
there
about
is, even the Deputy Commissioner is account, as I stated earlier, Lordship, Deputy Commissioner is accountable to the government and to the Accountant General, Lordship. And there will be an audit. So all those procedure has to be followed, Lordship.
Okay, I'll give you enough time. You've
Lordship.
already taken.
Lordship.
And now we will give you some time and then finish the formalities.
Lordship,
Maybe by-
Now the formalities are over.
Lordship, all over, Lordship.
Recognition
Now-
or identification of the people are there.
Lordship, in fact, Lordship, I have submitted documents, Lordship.
Mm.
There, out of the beneficiary list, out of 177, Lordship,
Mm.
till date, 16 July 2025, 65 of the beneficiaries are already received.
65.
65.
Ah.
Now the remaining 112 is there. And
Ah.
Lordship, in fact,
Remaining, so many of them are there.
so many.
It's not like
65, right?
65.
It's 177 is the list.
177.
is the list, out of it, 65 beneficiaries
Yes.
already received. And the remaining one.
More than
one-
100 is
one-
there also.
So
110.
Lordship, if, Lordship. So,
I'll not dispose of the application.
Yes,
I'll keep it alive.
Lordship.
And then you do it, finish the process as soon as possible.
Lordship.
Give your date
Have it on-
and file a compliance report.
Lordship.
Also can have it on 8th or 14th.
Okay.
That will be around 3 weeks or 4 weeks, almost 4 weeks. I think that will be enough time for them to.
Heard Mr. A. Sharma for the
On 20,
Not 20, that is too much, Lordship.
on 20.
20 is too much.
20 what? 20th of
20th
August.
of August, Lordship.
It's too long. Why? You,
Make so much of that.
2 weeks, you take 12th of August.
Lordship, there is a shortage of manpower in the Deputy Commissioner's office as of now,
Okay.
Lordship.
So many
Some,
excuses.
Lordship, some have taken the casual leave also, Lordship.
12,
They have available leave.
Acha,
leave.
acha.
So
Sir,
if- to
agree
be on the
on
much
next-
safer side, Lordship. On 20,
12
on 20.
14.
Okay. And now he is pressing on 20. So, okay,
Lordship,
18th,
if we
Monday,
cannot comply on that, Lordship, again. we
Monday,
have to extend.
18th,
So.
18,
satisfying both the sides?
Lordship.
Yes.
somewhere in between.
18th, yes. This is a contempt application. Oh, heard Mr. A. Sharma and so and so. This contempt application is filed for the violation. And I'll not say even here willful, for
Lordship. In fact, we have
non-compliant, for violation and non-compliance of the order dated 7/2/2024, by which the learned court,
In
the
PI.
the honorable division bench had ordered in a public interest litigation being PIL number 1 of 2023 that the state government would submit a proposal along with the assessment along with the assessment to MORT. What is MORT?
Ministry of Road and Highways.
Oh, acha.
Road,
Ministry
Transport and
of
Highways.
Ministry of Road and Transport Highways
Yes.
within a period of 1 month.
3
From-
months, it says 3 months.
Huh?
No, 1 month.
1 month. Within a period of 1 month from the date of receipt of the certified copy. The Honorable Court further directed that the MORT, that is Ministry of so-and-so, upon receipt of the proposal, shall within a period of 3 months accord sanction and make the required fund available to the state for disbursement to the affected landowners. For disbursement to the affected landowners through the Deputy Commissioner or the District Collector concerned. The Honorable Court also directed that the Deputy Commissioner, upon receipt, may disburse the compensation amount to the landowners immediately by observing formalities.
The word was shall.
Uh-huh.
Shall.
Oh, yes.
Shall
Where-
disburse.
Shall.
Yes.
Okay. What did I say? Upon receipt, shall disburse
Yes.
the compensation to the affected landowner immediately by observing the formalities.
Yes.
By giving the said directions, the said PIL was disposed of. During the hearing of the instant contempt petition, did I give the date of the judgment? I gave, na, February?
Yes, Lordship.
It gave out. During the hearing of the instant petition, contempt petition, the respondent number 5 had filed an affidavit wherein affidavit on 11th of July 2025, wherein at paragraph 5 of the same, it was stated that a circular was issued on 11th of June 2025, wherein all the concerned affected landowners were informed to come in person for disbursement of the compensation amount. they were informed to come from 18th of June, 11 a.m. onwards. It was further stated therein that a substantial amount for the substantial amount towards compensation has been paid to the affected landowners. Full stop. The counsel appearing for the petitioner states that the said statements do not reflect the proper compliance of the order of the Honorable Division Bench. He stated that the respondent did not specifically state as to the amount given to the respective landowners. No. He states that there were, cut that, he states that there were 177 beneficiaries in view of the order of the Honorable Division Bench, but the respondent number 5 in his affidavit did not specify as to the number of as to the amount of compensation given to the number of beneficiaries, and that the statements were vague in nature. The counsel appearing has what happened? Where is your document? Yes.
Lordship.
You had given one, no? Mr.
Lordship,
Sharma?
one-
No, Mr. Sharma had given
Regarding
one.
lordship.
Yes, this one.
Yes. Lordship.
During the course of the argument, Mr. Sharma has produced a list of the beneficiaries who have not received the compensation amount till date, and the list consisted of 98 numbers of beneficiaries.
And who appeared before the Deputy Commissioner on 15th by way of a representation demanding the money.
He had also stated that these beneficiaries had appeared before the Deputy Commissioner claiming their compensation amount on
15th of July.
15th of July 2025.
Receipt is there, bottom lordship. ADC's receipt is there, that first page, bottom side.
Oh yeah, this one.
Yes, so just to,
Yes,
which has been duly received by the ADC.
yes. And along with her representation, the beneficiaries have approached the Deputy Commissioner along with her representation, which was duly received by the respondent number 5. As such, he states that out of 177 beneficiaries, only
Today the list produces 65, they are saying. So
only-
112 is remaining.
but then you said 90.
So
here.
out of 112, 99 had approached on that day.
Okay.
Maybe some could not have gone that day.
Yes.
But 99 have gone that on that day. 99 or 98 out of the 112.
As such, he states that out of 177 beneficiaries, many of them are left
Yes.
to receive the compensation amount. Mr. So-and-so appearing for respondent number 5 have submitted and have produced the documents with regard to the payments made to the beneficiaries.
Lordship.
He has placed, here there are 65.
Lordship, here are first page. The first page is the total beneficiaries.
He has placed that till 16th of July 2025, 65 numbers of beneficiaries were paid their compensation out of the total beneficiaries numbering 177. he also states that 112 numbers of beneficiaries are yet to be paid their compensation.
Lordship.
However, he states that before payment of the compensation, there are many formalities and many procedures to be undertaken by the respondent number 5,
Lordship.
as he was responsible towards the concerned authorities
Lordship.
for payment of the same.
And there is some technical difficulties, Lordship, in issuing, in discussing.
In compliance with a court order, these kind of excuses
Technical.
probably, there's a court order, they have to comply. Technical problems they should keep to themselves and not place it before his honorable.
Okay, I'm
Because
giving
of
you
that,
time, don't fight.
it's taking some time, Lordship,
That's
because
okay.
of that technical difficulties. Other than that,
Mr. Sharma also states that as far as the total compensation amount to be paid to the beneficiaries, there is no dispute.
yes,
Inasmuch as in the order itself it was reflected that the total amount to be disbursed was to the tune of rupees 4,009,719.74, which was accepted by the respondent authorities.
Paragraph 9.
Respondent,
Yes, paragraph 9.
a paragraph,
That-
which was accepted by the respondent authorities and the same was reflected in paragraph 9 of the judgment dated 7/2/2024. Since in the judgment, in the said judgment, it was reflected that, it was not reflected, it was ordered that after the assessment and the required sanction of the amount, the Deputy Commissioner should disburse the amount immediately by observing the formalities. It is therefore directed further that the Deputy Commissioner would complete the process
Lordship.
of disbursement
Lordship.
of the compensation amount to the beneficiaries, to the rest of the beneficiaries, that is 112 in numbers.
Lordship.
Must will give a time frame.
Within?
No, Lordship, since the matter is listed on 19, on that very day.
As
we
soon
will
as
be filing
possible.
our affidavit in compliance. Compliance.
As soon as possible.
Lordship.
As soon as possible.
As soon as
Lordship,
possible.
yes. We cannot give a time.
The respondent number 5 is thereafter directed to file an affidavit in compliance of the order.
Lordship.
List the matter on
18.
in between. If
18.
some requirements, I'll change. Huh?
Lordship.
On 18th,
Lordship.
not 18th.
18.
18th.
Lordship.
I was suggesting 14.
18 Lordship was
Monday.
suggesting on
Okay,
Monday.
yeah. List the matter on 18th of August 2025.
Obliged.
So in the event of default, this
Ah,
honorable court, no, this kind of sentences
yes.
probably is required by looking
Lordship,
at the.
we have already complied with the order
So
of this
why?
honorable
Why-
court.
why are they then afraid to have
There is
a-
a
But
substantial
very
compliance.
slow,
Lordship.
very slow.
Yes.
Lordship,
Of course, we know Deputy
Lordship,
Commissioner
there is
has
a
other
technical
work also.
difficulties, Lordship.
He is busy, I
And then,
know.
Lordship.
But then still, this is court order.
Lordship.
One has to follow.
Lordship, Lordship. I'll
Okay.
file my
As soon as
compliance
possible.
certificate.
And
At the last lawsuit been recorded. In the event of default, this
No,
honorable
Lordship,
court.
Lordship, this is a compliance affidavit. Lordship is well aware, Lordship, in the cantina of judgment, Lordship. When there is a substantial compliance, Lordship, it's a compliance at all, Lordship. Lordship is aware, and Lordship will appreciate that, Lordship.
No, this is
So,
incorrect.
Lordship, this is
Compliance has to be
Lordship,
100%
Lordship,
compliance.
This is a compliance, Lordship.
it is further directed that the Deputy Commissioner should not delay
Lordship.
the matter
Lordship.
any further For the
Lordship,
ends of
from-
justice, should not delay any further for the ends of justice.
Lordship. Oblige, Your Lordship, oblige.
This one and this one will keep it.
Lordship will keep it in the
Lordship,
record.
Lordship, that's maybe part of the report.
Oblige, Your Lordship.
Chief,
For admission, item number 1.
Oh, yes. Now you're
My-
audible.
my lord, now I am audible.
Yes, I can hear you. This one.
Yes, your lordship.
Loud and clear. Yes.
My lord, the matter is dragging since 2022, your lordship. This is a petition under 482 for quashing the FIR and this one CR.
One
Many
reply affidavit was supposed to be filed, that is not done. What happened? Oh, you were supposed to file reply affidavit.
Your lordship, I do not require to file any more affidavit, your lordship.
Oh, no, it is already filed. Reply affidavit filed on behalf of the petitioner. Okay. You are appearing?
Yes, I'm for state.
Yeah, you are the PP?
Yes.
Yes.
Main party is not appearing.
The informant.
The main
Yes,
party.
yes, your lordship. She is the informant. She is the complainant. Your lordship,
It is complete.
yes, your lordship. And they appeared also.
My
many times.
Lord,
Yes.
I'm sorry to interrupt. I've just been informed by the respondent number 3. The council, due to technical reason, they cannot appear. So I have been informed to appear on behalf of respondent number 3 for Mr. Manas Kumar Das to make an adjournment on behalf of the leading counsel because he is unwell today. So can a matter be taken up after 1 week?
He is saying that the counsel is not well.
Yes, the leading counsel.
But otherwise, respondent number 2, the informant,
Three.
has not much role. It
Respondent
is
number
the FIR, quashing of the FIR. PP.
Leadership, there's a CR.
Oh, this is a complaint case?
Yes.
Acha.
Both complaint and
Yes,
GR also there. Your lordship, I beg to take your lordship to page 34 of my petition.
No, there is a prayer on behalf of respondent of the informant
I do not have the brief also.
that he does not have the brief also and then his senior is not well. So
No,
let
the-
it come up next week on Tuesday,
Can it be on 23rd, Lord?
23rd,
Third.
Wednesday.
This Wednesday.
Yes, okay. Wednesday there is no division bench. So on Wednesday we will take it up.
Yes.
Much obliged, your lordship. Your lordship, actually it should be, finally he should come, your lordship, because like this.
No further adjournment, otherwise he will do. He
My
is
lord,
given the undertaking.
My lord.
Mr. So-and-so appears for the petitioner. And Mr. So-and-so appears, Hari, the government and the PP. And Mr. So-and-so for respondent number 3. The counsel appearing for respondent number 3 submits that the conducting counsel is not keeping well and that he has prayed for some accommodation. Prayer is allowed. List the matter on 23rd of July 2025.
And therefore, this should be a last chance to be given to them.
Yes, I'll be there. I know he knows me. I know him. We'll do it.
Okay. Much obliged, your lordship.
Lordship, there's an interim in this case, Lordship.
Which one? One? Acha. Interim passed earlier shall continue till the next day.
Must apply, Lordship.
Yes.
For admission, item number 29 from the supplementary cost list.
29. Orders. Admission.
May I please, Ladyship?
Yes.
Ladyship, this is an application for quashing the FIR and charge sheet. This matter, it was part heard on last day before yesterday. And then we have heard this matter to some extent. But then since the donor PP was absent, he was not there.
No, last order was mine and it is written that he was handled by one of the other colleague. Acha, okay. Show me the FIR. This is quashing of FIR.
Yes, Ladyship. FIR is a page 22, the type code.
Page?
22.
No, just see the prayer once. What is your prayer?
Charge sheeted case.
And the proceeding is on. The trial is on.
Trial is yet to commence.
Yet to
And the parties have entered into a compromise. Parties.
Oh, yes, you said that.
Yes.
And charges are framed.
Charges are framed, but then trial is yet to commence.
Show me the FIR.
Page 22. Hello.
Page 20?
2, that I copied.
Yes, yes. Yes, read it.
Yes, may I read?
Yes.
To the officer in charge, Kubota Outpost Newland. Subject FIR. With reference to the subjected cited above, we the Lotovi Village Council are obliged to bring forward the grievance to your esteemed office that, sir, Mr. Salman, son of Chora, a resident of our village, has been kidnapped by 4 unknown miscreants who happened to come from White Alto car around 4 to 5 p.m. on 12th of August.
Oh, that
Yes.
you picked because you had to give money and then,
Yes, yes,
right?
yes, that case.
Who was supposed to get money? Who? I forgot.
The petition number 3.
Petitioner number
And the alleged
3.
victim are relatives.
Acha. Yes, petitioner number 3 lended,
Yes,
loaned
to the
the
alleged
amount
victim.
to the
And then
victim. And so
to
the
recover
victim
that,
was
yes,
picked up.
Yes,
2 lakhs.
yes.
So
in that
there was a
case,
compromise.
yes. Ladyship, I want to place a reliance on these 2 judgments.
Yes.
The first judgment, which is of Madras High Court, in this case, the facts, the sections is also same. And then the facts and circumstances in this instant case is also same because of the financial dispute that has happened between the
But whether
petitioners.
he was kidnapped, he was picked up.
Yes, in this case also same thing.
Where is that? Show me the
Yes.
paragraph.
There are, the section can be seen at para 2, second page. And then the complaint can be seen at para 5. Ladyship, in this case,
364A.
yes, now 140 subsection 2 of BNS, same section.
364 is kidnapping for
Yes,
ransom,
A,
right?
A is for ransom, same. So in this case also, there are 3 petitioners in this case. And then the second respondent was the victim.
In this Madras case?
Yes, same case. So, in this Madras case, the petitioners and the respondent number 2 are known to each other. So, the respondent number 2, who is the victim, he runs a travel business. So, the petitioners has invested amount of rupees 6 lakhs to the respondent number 2, and then the petitioner went abroad to find a job. Since he could not find, he came back, so he demanded that 6 lakhs which he had paid. So the petitioners came to his shop, and then the respondent number 2 was picked up, he was taken away. So the employee, who is the de facto complainant, had filed the FIR on his behalf. Soon after they were arrested, they were released, the compromise was same like our case, in this present case, same case.
And
So
what
in-
about, yes, some more paragraph you want to show?
Yes. In this case, reference has been made, your ladyship is well aware, page 7.
Page 7.
Yes.
Parbat Bhai.
Yes. All these cases, Narendra, Gyan Singh, all this has been highlighted.
Narinder Singh,
Yes.
Gyan Singh, and
Yes.
there was one more Parbat Bhai also, no?
Yes.
Same line.
So all these cases have been mentioned.
Okay.
And then in the second citation which I have, that is of Narendra Singh, I'm relying on para 29.
This one we know.
Yes.
So what do you say? You are for the private respondent, or you are for the other one? You have entered into?
Yes,
You have
yes.
signed?
Yes.
This is not a joint petition, right?
Not a joint petition.
1, 2 and 3 are the petitioners. They are the accused persons.
Accused persons.
And you are for respondent number 2 and 3.
2 and 3.
And the affidavit was entered into by you both.
Both the parties, all the parties involved. Including the family members who were
Akosha,
present.
Sushi and Salman. And so and so.
That compromise deed is at page
Affidavit.
23 and 24.
Nometo Yektomi. We authorize. Signature is of only Nometo. Oh no.
All the
All of them
persons
have signed.
Yes.
I'm just seeing the signatures.
And then in this compromise deed, the father of the alleged victim is also a witness to this. In page 24.
Signatures appears to be okay. And the first party, Okesho Simi and Salman. Okesho Simi and Salman. And what do you say, Miss Pipi? Of course, in small offences or matrimonial, any other civil suits, okay, there this thing can be done, settlement. But there, here, what is seen is that he was picked up from his shop, right? And then
The offense is serious, Your Lady. It is affecting the society as well. So, Your Lordship, the offense charge levied against the accused is non-compoundable and the ground for compromise is not tenable in the eye of law. So, I have a strong objection and the accused should face the full trial.
But one thing, there is one condition or one guideline in these cases where it is said if there is no chances of conviction or if the trial will be useless, it's an abuse, then in that case even I have seen even attempts to murder case are being settled on settlement. So here what it seems is that he was supposed to pay money, the victim. And the victim was picked up, paid 2 lakhs, he was asking and he was not giving. And then he was picked up and then here, money was taken from him. Right.
Your Ladyship, if Your Ladyship will see the statement, there is a clear intention. There is a clear intention, Your Lady. And even the trial court records has been called. So if Your Lady may kindly peruse that also.
Of course, the statement before 161 will not be,
Of
because
course,
it is
of course. That
after.
is what- yes, Your
In
Lady.
161, though, they will allege, they will.
So Your Lady may kindly peruse 164 before the magistrate, the confessional statement of the accused.
But can you please take out the 164? It might be in local language also. It's there. $164 is also before the settlement.
Yes.
Settlement was
They were arrested on 13th of August. And then the charge sheet was filed on 27th of August, 14 days after the arrest. Settlement arrived on 29th of August, 2 days after the charge sheet was filed.
Charge sheet
Due to
when?
this reason, the charge sheet could not be, the compromise deed which we have submitted could not be incorporated in the charge sheet.
No, it's okay. Charge sheet what date?
27th of August 2024.
After 2 days only this
Yes,
was done.
compromise was entered.
I'll just see the charge sheet once. Wait.
That can be seen at page 25, charge sheet, annexure D.
29. Yes, I mean the contents are in 29. There are 3 accused, right?
3 accused
And then
persons.
in charge sheet, why they are saying 2 accused persons?
Must be a typing mistake.
Both the accused into police custody.
Initially, petitioner number 1 and 2 were arrested on the same day.
Acha,
Petition
acha.
number 3 was arrested after 2 days.
Okay, that is why.
That is maybe.
He saw some local persons, so he knows them. The victim.
Yes.
He saw some local persons proceeding towards his house. He followed them, reached his house. They first asked for drinking water. All the mobile aunts, his fathers, mothers.
They are all from the same area.
After they asked who is Salman, he introduced himself there inside the vehicle and reaching 4 lane, blindfolded his eyes and took him to an unknown place. They beat him up and asked him what type of black business he was involved in. He was beaten up. This is what is the statement.
That is the statement.
He told them that he is not involved in any black business, but kept on asking him what type of black business he is involved in.
Yes. 183. 183.
Oh, the father had taken the money to a particular junction, and that at that point of time, the police came and arrested.
Yes, on the pretext of giving the money, they were called and then they were arrested. But we have never received the money.
Your lady, 183 statement is not here on record, Your Lordship.
164, acha. Maybe he was not examined.
164, as far as I'm concerned, 164 is not there because I have annexed the entire charge sheet.
CD 161 statement of victim and all, of course, those are reflected here.
161, yes.
161
161 statement is annexed in the petition, Your Lordship. Your lady.
That is a page 36.
And it's
Page
36.
41. Page
And it's
41
in-
is the statement of the present accused. The second para.
Page 43.
Yeah.
We have also admitted what we have admitted in the petition. The statement remains the same.
Where is the statement of victim, you said?
Victim is at page 36.
Where is your... I mean, your compromise deed is also 2 pages, not 1 page. First party has filed the FIR against the second party, registered. Complainant on behalf of the alleged victim has filed an FIR against second party. That due to some financial issue between the alleged so-and-so and alleged, who are both relatives, a misunderstanding arose, but the matter has been resolved. Both the parties in order to maintain cordial relation. They are otherwise relatives, right?
Addition in this case,
But then
the compromise deed, they are also aware of the fact. The parents were not aware of the fact of the financial that was pending between the petitioner number 3 and the respondent number 3. Only after
where
the
is the
case,
father's statement? Father of Salman?
Yes.
838.
that is page 37.
37.
37.
I mean, this father, he went to the village headman, right? Some council
Council
chairman.
chairman.
And the council chairman said that, okay, he will personally look into the matter. Then he got calls. And then he arranged the 2 lakhs. Then he reached the place where he was called. Then he was again called to another place. He said, I cannot go. And then in the meantime, 2 persons came. And the police also came and arrested. And whether that is believable? I mean, he did not go to that particular place where he was further asked to go. And then at that juncture, 2 persons approached him. And during that time, police personnel in civic arrested them. The accused also came, police also came. Because why I'm looking into this, whether there are any chances of conviction. Because otherwise the offense is serious.
Yes, yes.
Kidnapping the son, telling the father to bring the money, they are all farmers. They went. But then this particular thing is little not very, I mean, and the this deed of agreement is also very, very vague, very worded in a very less manner. I mean, see, they have said they have financial issue, and then their relatives, there was a misunderstanding.
It's a private settlement. Now, when the offense is impacting the society, affecting the society, whether that can be allowed, the lady.
Ladyship, if you can kindly come.
Because in Narendra Singh and all they say which does not affect the society, you can. But here, the unknown person came to his house, and then the father was not there. They took him. They took him. And then he kept in some unknown place. Next day he was.
Ladyship, if you can come to page 6 of the judgment which I've given, Madras High Court judgment. Just for
Every
reference.
case has its own peculiar
Yes,
facts.
Yes.
Which
In
paragraph?
this para 6, page 6, para 8, page 6. Just want to point out this part.
Objective
May I
to
read?
the quashing.
Yes. Since the learned APP objected to quash the state proceeding stating that the offence under section 364A IPC is uncompoundable one, the matter was returned to today when the matter was taken up for consideration after hearing the submissions made on either side. I have carefully gone through the complaint and other documents and I find that the first petitioner is well known to the second respondent and the dispute in question is between these independent parties having grace of private and personal nature and also having overwhelmingly and predominantly civil flavor. This is which I wanted to point out, Ladyship.
That's why you do one thing. You file an affidavit. Respondent. Right. You file an affidavit. Only after that we can decide. Okay. This is an application filed for quashing of the FIR. You file it within this week. I can take it up next Tuesday. Okay. For quashing of the FIR dated 13/8/2024 as well as the charge sheet dated 27/8/2024 and the subsequent proceedings in connection with the police station case number New Land in connection with New Land police station case number 24 of 2024 registered under section 140 subsection 2 read with section 3 subsection 5 of the BNS. The petitioner has prayed for quashing of the said FIR as well as the charge sheet and the proceedings mainly on the ground of settlement being reached between the petitioners and the victim and his father. There are two
Complainant.
Complainant has got nothing to do with the settlement.
Chairman of the
Please tell me. Okay, between the petitioners and the victim, in which it was stated that the FIR was lodged and FIR was lodged due to some misunderstanding, inasmuch as there was some financial issue between the victim and the accused persons, who are again relatives to each other, who are again related to each other. Full stop. By the said deed of agreement, the parties have agreed to amicably settle the disputes. Since this is not a joint petition between the petitioner and the victim, and the respondent and the victim was arrayed as respondent number 3, it is desirable that respondent number 2 may file an affidavit stating his own stand. As such, respondent number 3 is allowed to file the affidavit, list the matter on 22nd of July. Okay, 22nd of July 2025.
Obliged to ladies.
For admission, item number 13.
Keep these here. Item number 30. This is IA in a bail application. What is this IA for?
For regularization of the interim bail.
Oh,
For
he had
regularization.
surrendered.
Lordship.
Oh, acha, for regular bail.
Lordship. For regular bail.
The case diary is here.
Lordship,
The
this morning I have contacted the IO of the case. Lordship. It seems that the matter, this instant matter, Lordship, the accused has been charged with it, Lordship. So
Acha,
I'll leave it to you. Since it is already been charged.
you approached the trial court.
My lord, since it is a genuine case of medical emergency, I pray that this honorable court exercise is discretion judiciously in the interest of justice. Because if I again approach the trial court, I have to wait for another 2 weeks for the status report. Which
Why 2 weeks? Courts are not sitting over.
in case if I approach the trial court after filing the application, it will take another 2-3 weeks.
No, why 2-3
status
weeks?
report.
They'll call for the case
So-
diary and then because the charge sheet is submitted, it's better you approach the trial court. You file the application tomorrow. Well, you have the charge sheet number and all.
No, Lordship.
My lord, it's not in the court file. It's not officially filed. It's not in the court file. Maybe it's still with the PP, with the special PP, but it's not in the court file.
You get the proper instruction whether it is filed or they are likely to file.
Lordship, as far as the instruction that I received, Lordship, it has already been charged. That is what
It's already been filed.
My lord, his review is on 19.
Hmm?
His review is on 19/7/2025, day after tomorrow. And my lord, since he already went a keyhole surgery, his review is very much
Where is keyhole surgery?
on page.
Or I can give him interim bail again for a few days and then let him go and get his treatment done and for till a particular date,
Lordship.
and then he will surrender, and in the
My lord, in the interest of justice, if this, I pray this honorable court mechanically regularize his interim bail order, because the other co-accused is also already released on bail.
now you want what? What is your prayer?
To grant me regular bail.
Acha.
Yes.
No, do you have a judgment where it is said even after filing charge sheet, High Court can continue hearing regular bail? Do you have some judgment? It is otherwise a law. Even after filing of charge sheet, High Court can hear. Whether you have the judgment on that?
I don't have the judgment, but it's up to the court discretion to grant regular bail, my lord. And this is the bail order of the co-accused, who is already released on.
This bail
on
order is
service of
granted by
ground of
High Court.
arrest. Yes. I'm only concerned with
Acha, by the special judge.
this, my lord.
So you can also move before this is NDPS case.
Lordship.
Yes, my
This is
lord.
an NDPS.
Yes, my lord.
You can move before the special judge. Here also, and the charge sheet is filed. And get a covered order.
Yes, my lord, since it is a medical emergency, if I file the application in trial court, it will take some days, more than a week.
Well, let me see the FIR.
In bail application, my lord, I've annexed the FIR.
Is it commercial quantity or what?
It is commercial quantity, but here, my lord, no drugs were seized from my possession. I was just arrested based on the statement of the co-accused.
But then section 37 has to be gone into.
Yes, my lord. Here, all the other co-accused are on bail, and from the other main accused also, no materials were seized from the other co-accused also. It's just on the.
Where's the FIR?
investigation. On page 17 of the main bail application, lecture 3 and 4 series of the main bail application.
Yes, this is the IA. Huh. Per page?
Page 17, my lord.
And your name is NJ Avigongla. Main accused is Jitendra Shah.
Yes, my lord.
Where is your name in the FIR? You are not named.
No, I'm not naming the FIR.
You're not
only
named.
a later part, based on the investigation, only I was arrested. But
Since it is a racket, it seems I have not gone in details, but let me, what I do today is I'll issue an interim bail order, and then you go and have your treatment and you produce your case diary on the next date. Okay. So heard Mr. So-and-so for the petitioner, as well as Mr. So-and-so, the learned PP. What is the prayer in your eye only for interim bail?
to regularize my interim bail order.
By this interlocutory application, the petitioner has prayed for an interim bail order You have already surrendered after this bail order, so why regularize 2-5? 2-5 order is gone. You have surrendered, now he's inside. Now you'll have to have a fresh interim bail order.
I'm praying by filing this IA, I'm praying before this honorable court to regularize my interim bail order.
Interim bail order 2-5
Yeah.
is already over.
Yeah, it's over.
It's over, you have surrendered. This was disposed of.
So I'm praying for
Because
grant of regular
14.7
bail.
14.7 it was listed and 14.7 you surrendered.
I filed, this IA was moved on 14, praying to regularize my bail order, the interim. But this Honorable Court fixed on 17 to allow our
That's
RTP
okay.
to take instruction.
For an interim bail order on the ground that the petitioner is medically unwell and he has annexed the medical certificates to that effect. On 2/5/2025, the learned court granted an interim bail for 2 months, that is up to 14/7/2025, on the ground that the petitioner may be treated in the Nagaland, what is this hospital? NHAK.
No, after the interim bail, he took treatment from 3 hospitals, from Senapati District Hospital and
No, otherwise 2/5 order says that he was to be taken to NHAK for further medical examination. Right. So what did I say?
No, my lord. Based on the treatment from
on the ground that the petitioner may be treated for his ailment. Thereafter, on 14/7/2025, the petitioner surrendered before the court, jurisdictional court, or no, before the jurisdictional court, and presently the petitioner is inside the jail. Petitioner is incarcerated in the district jail, Kohima. The learned counsel for the petitioner has placed the medical report dated this is what dated? Where is the date here? Where you are sent for review on 19/7?
That is on page 36.
Dated what? 14 June?
Yes, my lord.
Yes, 14 June 2025, in which by which the petitioner was directed to review his health on 19/7/2025. The counsel also states that the petitioner's health condition is very weak due to the various ailments. The diagnostic report also reveals that the petitioner is suffering from prostrate sarcosoma or what?
Benign prostate hyperplasia.
Where is that?
On page 3, on para 2.
No, these medical reports.
On page 34, the concern.
34, okay, yes.
Page 34.
diary reveals that the petitioner was suffering from prostrate carcinoma and he was diagnosed with BPH. What is BPH?
Benign prostate hyper.
Which is a
prostatic
pastry.
Acha.
hyperplasia.
BPH dot. I have considered the medical reports, and since the petitioner was called for his health review on 19/7, this court, considering all aspects, by considering all aspects, grants him an interim bail for one month, grants him for interim bail or lesser than that. 19 his health will be reviewed. So today is what date? Today is 17th. 17th. So let him surrender on 7th of August.
My lord,
7th of August will be sufficient time. Okay. So interim bail for 15 days. Right.
at least 3 weeks, my lord.
Huh?
At least 3 weeks.
Bail for 3 weeks for his treatment. 3 weeks from today. 3 weeks from today. That is up to 3 weeks. So it's, today is 17. That is up to 7th of August. 7th of August. For treatment, on executing a bail bond of rupees same, on executing a bail bond of rupees 1 lakh with 2 local sureties of the like amount, to the satisfaction of the learned, to the satisfaction of the jurisdictional court, under the conditions that he may not tamper with the evidence or influence the witnesses connected with the case, comma, he will not leave the jurisdiction of the court, right?
That's right.
A jurisdiction of the jurisdictional court without the leave of the same, and with a further direction that he shall surrender before the jurisdictional court on 8th of August 2025. Then write, call for the up-to-date case diary. Wait, before that, Mr. PP submits before this court that he has instructions that charge sheet has already been submitted in the instant case, and that he may place the proper information. He may place the documents. He may place the required documents on the next date. Call for the up-to-date case diary as well as the prayer is allowed, not voted. Prayer is allowed, because if there is charge sheet, then we'll have to call the court. Prayer is allowed. List this matter on 8th of August 2025.
For orders, item number 4.
Item number 4. There was a prayer for adjournment.
Yes, my lord.
Acha. You wanted adjournment on what ground?
The service report is still awaited.
On?
Respondent number 10, 11, and 12. So I pray that this matter will be listed after 2 weeks.
Otherwise, my lady, there is no contempt in this case.
But then they have to come and reply, no? They are read as
No,
contemnors.
they are the newly included incumbent only. Because
Okay.
they're all incumbent, they had carried out the survey, the spot verification, and accordingly, we had to file our affidavit also, respective affidavit. Because the direction of the court is to conduct the spot verification, and if found to pay the compensation, and if the petitioner they are aggrieved with the fact-finding reports, they can approach the civil court.
Acha.
Yes. So
And
now we
according
have-
to you, it has been
Yes,
complied
we
with.
have
Spot
complied.
verification
Yes,
done.
everything done, and accordingly, most of the petitioners are not entitled. Only few of the petitioners' land have been encroached during the widening of the national highway. Yes, we have verified.
But
all
then
the
she does
documents.
not have the instruction today. Can you?
No, my lord. My senior is indisposed, so.
They have been adjourning the matter over and over again. Yes.
When can your senior appear?
After 2 weeks, or maybe next week.
Do it next week if they are saying that these are not required. Their services, notice is not required, and it has been complied with. We can close the matter. Let your senior come next week.
Okay.
Okay. Miss So-and-so prays before this court that her senior is indisposed, and as such she prays for some accommodation. Miss So-and-so, the additional AG, the additional AG for the state of Nagaland submits that the direction as given in the order dated, a direction given by this court, direction given by this court has been complied with, and that no contempt is committed, full stop. List the matter on. Next week, give 23rd.
23rd is Wednesday.
Wednesday, there will be no division bench, I think.
Okay.
So 23rd of July 2025.
Much obliged.
For orders, item number 5.
There also some adjournment was sought for.
The matter is under consideration, under process. So I pray that 3 weeks' time may be granted to be listed.
You have no
after 3
objection.
weeks.
Yes, my lord, I don't have any objection in granting some time. But then, your lordship, here after the disposal of the red petition, it's been 27 months. And then right now, only one division is being granted the said benefit. There are more than
One what?
one division.
Acha.
There are more than 27 divisions here. And then after the disposal of the red petition, I filed the contempt petition. Well, contempt petition was pending to file in IA, seeking for extension of time. Therefore, this honorable court has graciously granted 6 months' time. Even after expiry of the 6 months' time, again to file another IA. And then in the said order, this honorable court is clearly given no further extension. So, if the said respondents can complete it as expeditious as possible.
No further time, it was said in one of the orders.
Yes. That is not included in my contempt. Why? Because it was filed prior to, after filing of the contempt, it was IE 200 of 2024.
Acha, what, how much time you want for further?
Lordship, the matter is under process. So we can complete within 1 month. We can complete.
Another 1 month.
But to be on the safer side, 2 months within that time we can finish it.
After 1 month, file an affidavit. You are showing the progress. Or if you can complete it by then, fine, well and good. What is the direction? Where do I get it? Where is the direction page?
Court order is page 10. The relevant part is page 19 of my contempt. Page
No,
19.
18.
Page 19.
The last paragraph. May I read, Your Honor? Considering the above claim
It
of
is
the
page 18 here. Yes, considering the above claim of the petitioner association.
in the stand of the respondents in the counter affidavit, the writ petition is disposed of with a direction to the respondent authorities concerned to consider grant of time-bound scale of pay to the members of the petitioners association as expeditious as possible and within the outer limit of 8 months.
8 months was the initial order.
Yes. And then additional 12 months has been granted
After that,
already.
we have sought for
Extension.
extension
Yes,
of
yes.
time. So that shows that we are not deliberately violating the court order. We have the intention, but since it covers all over Nagaland, we could not do it on time.
Okay, Ms. So-and-so, the additional AG for the state of Nagaland submits before this court that there is every attempt on the part of the government to completely comply with the order, with the directions given by this court on
23rd March 2023.
23rd of March 2023. And she further prays that another one, some more time may be granted so that the exercise done by the government is brought to its logical end. The prayer is allowed. You are appearing for respondent number?
I'm for respondent number 3 and 10.
As such, the respondent number 3 and 10 were directed to file their affidavit. I'll give 1 month's time. File their affidavit by 18th of August 2025. 2025, full stop. List the matter accordingly.
That's right.
Bless.
For others, item number 6.
Please, Lordship.
Why has it come up? Awaiting service.
Lordship.
Still awaited,
Yes,
not
Lordship.
complete. When did you take steps?
Lordship, it was.
9/5,
Yes, Lordship.
May. Will you take fresh steps?
Lordship, I may be allowed to take by way of substituted notice, Lordship.
Why?
Even in the IA, Lordship, we have taken steps by way of registered post as well as substitute notice. Despite of notice, the sole respondent did not appear before the Supreme Court. In the IA was for continuation of delay. which was
I
allowed.
is not disposed of
It was
till now.
allowed. It is disposed of.
Okay. Now that the
Now
FA
is the
there.
appeal.
So fresh steps will you take? No.
Why we have substitute notice, Lordship, in order to see
What
right?
substitute?
Paper publication, substitute
Okay.
notice.
Or you take it through the police station? Police will search? Or a jurisdictional magistrate?
Lordship.
Okay. Heard Mr. So-and-so for the petitioner. They are sole respondent.
Yes, Lordship, sole respondent. Lordship.
No, so-and-so. In the office note, it is reflected. Office note dated 14/7/2005, it is reflected that the service report upon the sole respondent is not complete and is still awaited. The steps were, however, taken on 9th of May 2025. The counsel appearing for the petitioner as such submits that he may be allowed to take steps for service of notice upon the sole respondent through the jurisdictional magistrate as provided under the High Court rules.
Lordship.
The prayer is allowed. The petitioner is permitted to take steps of service of notice, fresh steps,
Lordship.
fresh steps for service of notice upon the sole respondent through the jurisdictional magistrate. List it after 2 weeks.
Lordship. Much good.
For others, item number 7.
This is contempt.
My lord, I have taken, after filing the request petition, I have taken steps upon resolution number 4.
Oh, you have impleaded or what?
Yes, my lord.
Ah. Then what happened? The newly incumbents.
Yes, yes. Yes,
Hmm. 14/7 only you have taken notice. Let us await. Okay.
yes, ma'am.
Heard Mr. You are for? The official, the government response. Yes. I mean not official, huh? J. Alam. You are for?
I'm for respondent number 1, my lord.
Okay. J. Alam.
Yes.
And you are for?
Respondent 2, the Executive Director of NHIDC.
Ramesh Prasad. What about 3/4? They are being replaced or what? 3/4?
I've taken steps on 3
On
and 4.
3 and 4.
Yes, ma'am.
Okay, this is newly impleted 3 and 4.
3 is impleted at the time of filing the contempt petition, but he was transferred, and the new incumbent
Is
took over.
4.
Yes, 4.
In the office note, it is reflected that the notice upon respondent number 4 is not served. And the same is awaited. The petitioner for the counsel for the petitioner prays that the service may be awaited since the notice was taken only on 14/7/2025. Prayer is allowed.
I think it's 14 June. I think so.
14/7 notice issued. No steps. Before that, no steps. 14/7. As such, the service upon respondent number 4 may be awaited. List it after 2 weeks. Oh yes, so and so appears for respondent number 1 and 2.
For hearing, item number 19.
Item number 19. 19.
My pleasure, Lordship. Lordship, the still leading counsel for the state could not turn up today, Lordship. So,
For the state.
Lordship, it appears that one of my colleague, Mua Chen, is actually handling the matter. And he is indisposed today, Your Lordship.
Lordship, I was told that let the matter be passed over for the day tomorrow.
Okay,
Since-
only for the day.
Yes, Lordship. Let it be listed tomorrow. I was told by counsel.
Heard Mr. So and so and so and so. It is stated at the bar that the council, that the government council who is dealing with the present case is indisposed and a prayer is made for listing the matter tomorrow.
Yes, Lordship.
List the matter tomorrow, that is on. Tomorrow is Friday, 18th.
Yes, Lordship. Deeply obliged, Lordship.
18th, you'll do the hearing?
Yes, Lordship.
This is on what?
Lordship, work charge regulation, Lordship. Work charge regulation. Seeking for
work charge
regulation.
regulation, okay.
Yes, Lordship.
Tomorrow we can do it and
Yes,
try
Lordship.
to dispose it.
Yes, Lordship.
This was the last matter. There were so many hearings. Okay. Okay.